எல்லாருக்கும் வணக்கங்க. Happy Sunday to all of you. Good morning, friends. On behalf of Greater Milwaukee Tamil Sangam, we welcome you all to the live discussion with our leading immigration attorney in the Midwest area, Ms. Mary Kennedy. We have traveled miles and miles to this country with dreams, and many of us have fulfilled them in few contexts. For many of us, continue to live in America through the legal immigration path is the biggest dream. Most of us are here in the United States for years and years and are waiting for the card, which is precious than the expensive metals like platinum or gold. Yes, the green card. As we legally wait, there was a surprise with the October 2020 visa bulletin, where many of our mainland people are eligible to file the last stage of the green card, which is the I-485/ the employment authorization or the adjustment of status. There were few confusions between the filing dates versus final dates. There were questions on the filing process. There were queries regarding the eligibility, and also the most important thing, finding appointment for the medical process. There were a lot of questions, open questions we had. We thought if we could coordinate our community with the immigration attorney, that would be the best help that we could do at this point. We approached our friend and supporter of GMTS, Ms. Mary Kennedy, from the law offices of Mary Kennedy LLC, and she wholeheartedly agreed to be on the screen to clear our questions. We also felt that there are confusion clouds with the patterns across our partner organizations as well, and hence we all join hands together to bring this session. Thanks to the Chicago Tamil Sangam, Michigan Tamil Sangam, Minnesota Tamil Sangam, Wisconsin Tamil Sangam, and also the Delaware Tamil Sangam. There were few other organizations who also reached out to us, and as we arranged it at the last minute, we were unable to have them. Thank you all for your help and support and having an extended support to the community. To explain about the law offices of Mary Kennedy, they have law offices in Hillsboro, Oregon, and Schaumburg, Illinois. They are assisting in the temporary visa, family-based permanent residence visa, permanent resident employment visa, the employer compliance, and any other assistance related to the immigration. So with no further delay, I'm welcoming Ms. Mary Kennedy, the immigration attorney from the law offices of Mary Kennedy LLC.
Vanakkam.
Good morning, Mary.
Good morning, Ashwin.
How are you?
Yeah, I'm doing good. Thank you. It's always good to connect with you all.
Okay. Thank you, Mary. Thanks for your Sunday's time.
Sure.
Okay. So Mary, you know the context for what we met today.
Yeah, sure.
There are confusions with the USCIS visa bulletin of 2020 October, and on the final dates versus the filing dates. Could you please clarify the difference between these two?
Yeah, sure, Ashwin. To start with, earlier it was always one day. The Department of State, issues every month on where the priority date or for whoever stands. And in 2015 September, President Obama, he came up with that, let's split into two. That's where it started with the date of filing and then the final action dates. The difference between those two, and then we'll move forward, what happened to the current scenario of now. So what happens with these two dates is, like, if you consider, it's easier for people to understand is, like, every year, most of us know that there is a limitation of H1 numbers, and for the masters as well as the general quota. The same way, consider this as something that, with the Department of State, the visa numbers are allotted. And so in that case, October is the starting fiscal year for USCIS on the allotment of the visa numbers. So what happens is every year they come up with these numbers, and then they assume, and October 1st, always there is more numbers on the top of the year. And then understanding till the end of the year, which is the September of the next year. So this is the number of visas that is available. and then they allocate. So the difference between these two in particular is, earlier, as I said, it was always one date, but now coming forward. So understand that, like in that context of, say, if you're filing a H-1B 180 days prior to your extension, you're planning to do it. So the difference between these two is like data filing, how it helps is like to prepare for that visa to be finalized. Say if you file a 485, there is a lot more of involved in the process. We'll explain it at the later point of time. But at this point, understand that, like you're filing your extension for a H-1B, similar to that. So they give one more date for the USCIS involves a lot of processing on the 485. So they say that, we'll put that as the final action date where it will be finally, you're ready for your green card approval, which is the permanent resident approval. But before that, let's give a date of filing, whereas you can file all the documents, assuming your priority date is going to be current at the end of the fiscal year, which is September, if in this case, September of 2021. Putting it together, so they say you guys go ahead and file all the documents that is going to be applicable for the 485. So in that case, they give a date of filing, and that is the cutoff date that we got it on this 3-4 days before. So based on that cutoff date, we are all going to file the paperwork, whereas USCIS is going to work on the filing dates, and then it goes on to the final action date. So am I clear or even simpler?
Yeah, you're pretty clear, Mary. Thank you very much.
So that's where it comes as two different dates. So the when it comes to the data filing, how it helps in the processes, even though your priority date is not, the final action date is not current, but as soon as you file the 485, you're becoming eligible to get your EAD, which is an open EAD, and then, it's not, like each individual is going to get it, like your spouse and you, and it's not dependent on other kind of EADs like H4 or anything. So
okay.
It is a very valid, like a 485 EAD. Until your permanent resident is going to be approved for you, you will keep on renewing the EAD. So
Okay.
that helps most of the people, and even with the travel, the advance parole also comes with a package, so that, that's the main purpose when they brought it in 2015, is to make people to be eligible, at least this benefits of the 485. And in 2008, there was an open call where everyone who had a I140 was able to, approved I140 was able to file it. But now there is a limitation of, the cutoff dates has been issued, EB2, EB1, and EB3, as we all know about it at this time.
Okay, so Mary, if I understand correctly, all the clarifications or all the confusions have been completed or resolved, and USCIS have given a green flag for all the eligible people to file the 485/EAD/AOS as of October 1st.
Right. Yeah. There was even my note on that. The small this one we prepared says that, like there was a confusion because it was like till this time, USCI is accepting only the final action date. It's not like that. They come up with, depending on so many other criteria involved over here. They say what they are going to do. Is it based on the date of filing or the final action date? They are going to accept the 485 package. So it was a mere confusion on that day. By 3 o'clock or something, they said, no, we are going to go only with the date of final action, which means you won't be eligible to even file for it. But then even I think
I think all those clarity. There was a hangama on that day, and people.
Yeah, there was a screenshot. I was just sending it to one of the employer, and then like he is sending me something, and it was like like as if it's very weird it happened, but.
We could understand the Wednesday or Thursday when the bulletin was came.
Right, Thursday. Even the next day, I forgot the complete day was gone for me.
You guys, we could imagine.
And,
we could imagine.
4 days for the call, and then I said, no, it's Friday today. So the whole day from morning.
Yeah, we could imagine that. Yeah.
Right.
Okay. So, Mary, thank you very much for the clarification between the filing dates and the final dates, and also clarifying that anyone who's eligible as of October 1st can file the applications.
Yeah, 485, right.
We would be aware, but still, I think there was one question which was asked. So the question was, is it they can send in the applications 1 or 2 days early and make sure that it reaches USCIS on October 1st, or is it like they should send it only on October 1st?
See, actually, so definitely it's going to be only to be received on October 1st. They have to be
Okay.
particular about it because,
Yeah.
even
Yeah.
before
This.
date, I know the postmark is fine, but it has to reach on October 1st, even if it's going to be at 3 o'clock even it's going to be at 6 o'clock and they are not open. But if the mail reached, there is an obvious, like a reason that they are going to send it back because they're particular about the dates, 1 to 31st. So it has to be reached, not postmark or anything. So,
Okay.
if they are sending it to take advantage of the old fees that's available on October 1st, definitely they have to make it 100%, like that they will be reached only on October 1st.
Okay. Thank you, Mary. Thank you very much. And the next question is a very, very important question. We got this question from at least like we would say 50s of people. And I guess you would know by this time what will be the question.
Right. Yeah. Okay. I understand.
The EB3 dates have gone. The priority dates have gone really, really faster, and EB2 dates are behind.
Right.
The question behind this is, can we downgrade EB3 to EB2 to EB3?
83. Right. Yeah.
Okay, I have a couple of questions.
Okay.
I'll go one by one, but I'll summarize the question. Number one is, what is the process of downgrading from EB2 to EB3?
83. Uh-huh.
And the second question is yeah, go ahead with this. I'll have the next questions.
Sure. Okay. So the first criteria is, when we talk of, is it possible? It's definitely possible. But the first limitation is it should be the same employer. So you can't go back to another employer who you're currently working or anything. This should be the same employer who filed the PERM for you. It can be very old, even in like 2010 or 2009, doesn't matter. But it should be the same employer who filed the PERM. They only can do the downgrading process. It doesn't matter that you have to be with them until this time, but as long as they agree to do that, definitely it is possible, doable. And what are the criteria that can be considered when you have to do this? I list it out as a one, and then you can have your specific questions based on what it is actually. So that is the one thing that you have to be very clear in mind. And then when you're looking at in the process of filing, some of the questions, frequent questions, is the validity of any PERM is only for 180 days. So now I'm looking at, it's like a 8 years, 9 years down the road. So how does it make it sense? Because, even if you miss one day on the PERM 180 days, they're very strict to reject the I-140 that is filed on that basis. So in that case, how does it work? So as long as one of the I-140 is approved based on the 180 days validity period, the validity period as well came up only in the later part of, I don't remember the year, but that was not the criteria earlier. Anytime they can go back to the PERM actually. So in that, all the scenario, yes, it is doable, even though the validity date is not there, but still it is a doable process. And, Ayla has given a very detailed clarification on how it can be done, how it is doable. It's not called an amendment or anything. It's another a filing completely where you have to pay the fee that is related to that. The old fee of 700 and the new fee is a little lesser actually. And so, that has to be done and then to be filed for on the old process of the PERM, and it is doable. And do you want me to continue? What are the limitations or what are the things that they have to consider?
We'll come there, Mary. We'll come there. So the question, I know you answered the question, but I would reiterate, or I would want to have this clarification, this thin line of the downgrading process. So the question here is, do they need to file a PERM and then wait for the PERM to get approved and then try to apply for I1?
No.
Or is it fine that they can go ahead and apply an I140 directly?
Yeah, no, there is no need of the PERM because the PERM takes very easily the prevailing wage and the recruitment process And now the period is also a little longer, so easily like 10 months. No, there is no need of any new perm to be done. As long as you have say that a company A filed for your perm and an I-140 was approved in 2012 on the EB2 category, and then now you're looking forward, talking to the same employer and asking them, can I do the I-140 on an EB3? Yes, you don't have to do any perm immediately, because all the documents, as long as the PLC site has been, like started with online. So the employer has access to all the prior documents of the perm the company has filed from the time of, filing. So it would say it is expired, but still all the documents are over there. So the employer has to download the document, and we'll be helping them out to send a new I-140 form along with the fees and whatever criteria that involves along with filing. That's it.
Okay, sounds good. Thank you, Mary. So another question related to this is, if we upgrade and file an I-140 in EB3 right now, what will happen to the original EB2 that got approved earlier? Will that be also valid, or is it something like they can have only one?
One, like job title that is associated with the perm actually. So that is a very good question. See, there are so many ALA forums also that is going along on that criteria. So at this point of time, how it works is, technically speaking, if you look into it, you're given a qualification of, like a EB2, whatever it requires, like, 5 years, 5 years experience based on a bachelor or anything. So it's a higher qualification. So when you downgrade to that of the EB3, the employer is saying that, like, I want this position and I'm able to pay for that, once the permanent resident is approved. I want to be filed on an I-140 on a lower category of qualification. So you're not going to the recruitment process or anything or redoing anything, but you're just downgrading to that of a lower, category of filing, whatever classified by the USCIS. So in that case, the general thought process on this is, because it's everything is new actually, like for most of them, we had always done it on another criteria, EB3 to EB2, where it involved again another perm, but that's not the case for this downgrading process. So one perm as such can support one classification of requirement. So the general assumption is you'll get another approval and another, associated receipt number to all your I-140, but still at this time period, it's going to be limited to the latest EB3. So after that, if I can go back and again go file another I-140 on an EB2, that is a, like a question, legal question still on. Actually, we have to find out little more details towards it. But at this point of time, definitely you have to understand that once you downgrade to that of the EB3, definitely that will be the thing that you'll be holding on to that of your perm.
Okay. So we can hold both EB2 and EB3 petitions with the same employer concurrently.
Yeah, the approval will be with both the criteria of, approval of I-140,
Okay.
but most likely the latest of the one, because you're downgrading to that of the EB3, that will be the latest applicable, qualification or the approval copy for that particular perm.
Okay. So the next question is questions maybe. So let's say that someone is having an EB2 and they have downgraded to EB3. And with this current scenario, let's say that someone is trying to apply an I-140 in premium, getting it approved in 1 week or so, and then they become current. They are trying to apply for I-145. If everything goes smooth, fine. Let's say that this is getting delayed and they are unable to do it in the month of October, and let's say in November, these people are unable to do it. My question here is, will they be able to switch the petitions according to the need in the future? For example, let's say that by November bulletin, let's say EB3 has retrogressed. I mean, sorry guys, I'm just all possible questions. So let's say that it has retrogressed and EB2 has progressed much more. My question here is, do you think if they be able to switch petitions according to the need in the future, let's say in November or December?
Okay, so the first is a few things I'll clarify. So, and how it's going to be is like, like okay, a person, an individual decides I'm going to go to the EB3 filing, downgrading to that of the EB3. The first, what our office, there will be different, like follow up, or what do we call process that each attorney office will be doing it on. So the first criteria is like, like we are not going to file it under the premium processing for the downgrade. The reason is like, USCIS, as long as whenever we file an I-140, they need the original of the labor. If we say that we don't have if it's lost or something, just for a general case, then what happens is they don't take it as a premium. We, specify to them to request, the employer authorizes them to request it from the Department of Labor. So without an original labor, usually it doesn't happen. You cannot file an I-140 on a premium processing. Premium processing limitation is 15 days. Earlier it was calendar days, and now they are going to make it as a business days, but doesn't matter. And one thought process, all the attorneys on the discussions, it's pointing out is like, if the same person is filed Texas Service Center and the Nebraska has the two I-140 processing centers. So in that case, if you're filing under the, the same center, obviously it goes to that of the center. And then in that case, they might accept the premium processing, but I doubt. The reason is there is going to be a lot more of filing based on this. And without an original labor, there is a possibility that it's going to get back. So I would, advise, this is what, again, as I said, this is our office for, processing that we are planning to do, is to prepare everything and file it under regular processing, and not to wait for that receipt notice or anything. If time permits, we are going to file it concurrently, even the 485, as long as you're eligible, considering other criteria. As said, we are not, each individual case has to be analyzed in a very specific manner and spoken to an attorney who is going to help you out. So concurrently filing might be the advisable thought process over here, instead of waiting, because even the I-140 general visit notice is going to take a longer time than the usual period, understanding all these, like the 4 years difference between an EB2 and an EB3 is a long timeline. So there are so many people who are already available and who's planning on to do it. So in that case, I wouldn't wait for that. Just concurrently file an I-140 downgrading based on the, it can be done, actually doable. So that would be the best thing to do. Is it clear, Asokan, or do I have to put it in a different way?
No. Thank you very much, Mary. I think this particular information that you said, that we can concurrently file I-140 without waiting for the approval.
The approval or the receipt.
Exactly. So I think that this would be an welcoming news to all, or most of the people who are thinking that we have to file the I-140 first, get it approved, and then apply
for the 485.
Right? Yeah. So I think, definitely this is definitely a welcoming news for most of the people who are, I think they would be jumping around.
Right. I understand, see, that's one of the things I am, like on the calls, see, honestly, it's doesn't matter whether they are going to do it with us or not. This is the need of the, this is so many questions. That's one of the reasons. So when I immediately said, we can do it actually, because this is all basic things. They have to be prepared. They're so panicked and they want to do it because it's a lot more of time. They waited. 2015, they opened up and they just recalled back. So, you can understand the pain and the emotions involved in this. So it can definitely be doable, not to wait for it and take a chance and then do it.
Yeah, definitely is. And this, as you said, the whole GC process is an emotional process. At least for the people from our mainland, definitely.
Yeah, right.
It is an emotional process and has a lot of sentiments attached with it.
Attached to it. I do totally understand that. Right. Yeah.
Thank you, Mary. Thanks for that. So the next question here is Mary. Let's say that Mr. X has an approved I140 and EB2 with an employer A, and now is working with an employer B. And with the new employer, they have not started the green card process yet. Okay. So the questions here are, number one, what are the options for Mr. X to proceed with the PERM? And number two is, can his new employer file an I-140 in EB3 to use the scenario right now? Or should the PERM process should be started from scratch and then it should go to I-140 or EB3? So you got the questions, right?
Yeah, I got it. Actually, it's
Okay.
just a little bit addressed it in the earlier question towards it. So definitely, as I said, I-140 on the EB3 downgrade is definitely going to be of the same employer. So in that criteria, like the new employer, as long as he has an, like a PERM, even though it doesn't matter, downgrading is very limited to the employer who filed it the first time. So the one thing is, even though he is not continuing with the same employer, the earlier employer who filed the PERM, so now he wants to go back and downgrade it to the EB, 3. He doesn't have to be with the same employer at this point of time. Like he can go back to the earlier employer, tell them that, I am, like willing. This is about the future employment, and after getting the green card and other criteria. I said there are very specifics attached to an individual. So definitely, I have to recommend someone to talk about their individual case. But on an overall basis, it's definitely going to be the first employer who has to file for the downgrade process. So in that case, the second employer, even though if he has a firm or process started and everything, it doesn't really help him out with the second employer, the current employer or the second employer to use the old firm and do it. No, that cannot be done. So they have to go back to the prior employer and tell them that they are willing to join after the approval. So the one criteria they have to look into it is the financial ability if they are not working for the same employer at this point of time. So the I-140 involves two a main thing that has to be proven to get it approved. One is the qualification, individual's education qualification, which I assume because it's a downgrade, they would have provided all the other documents at the prior time of filing. So they are very clear on that. So there's not a problem when it happens. But when it comes to the financial ability, if they are not continuing to work with the prior employer, that happens when the employer is of a company which has lesser than 100 employees on the payroll, then they have to prove the financial ability when it comes to the filing process. So I would definitely recommend someone who's seriously considering it to talk about this to the employer as well as an attorney. They have to review the tax returns. So many things are involved in here, and you can't come up with a generalized answer. So that is a very huge question. Anyone who is considering has to go through, talk to the employer as well as an attorney, find out the options, and then do it.
Okay, so thank you very much. So I think there were a lot of people who are having these concerns because once they all move to a different employer for their own reasons, they would have moved to a new place. So the questions, I mean, as I said, these questions were going back and forth because they didn't start a new green card process with a new employer. So I think they all may not be able to use the scenario with the current employer, but still chances that they can
The
always
options
go
are
back.
open, like, yeah, they can talk about it, and, like, there are so many, possible ways. They don't want to discourage them. So they can talk to them and find out the solutions about how it can be done, possible ways of doing it. But definitely this involves very specific, advice or a legal counsel to be involved in that and then do it.
Okay, sounds good. Thank you very much, Mehdi. So the next interesting question is, how did all in a sudden the, the dates came these rapidly faster?
I think, Ashok, we have to have a private call on that.
Okay, no, these were the questions that we had. Okay.
Trouble now.
Okay, so I'll have a connected question later to it. So with this a rapid movement,
Right.
I mean, like, and the US in the visa bulletin also they have very clearly, or I mean, they also had a note that in the upcoming months the dates are going to rapidly move up front. What are the higher chances that do you think that the dates will get retrogressed? They have a clarification, but still, as an experienced attorney, immigration attorney, you have been in this field for a long time, and we have seen this in the past also. Back in 2007, when in July 2007, when they made current for India at least. I mean, India for at least they made in all for all the criteria, like if all these were current, and by end of July, or at least by when the August 2007 bulletin came, people were all shocked. I mean, like it went like years and years back.
Right. Yeah.
Okay, so the question here is, yeah. So what do you think? And with the note that they have put that there will be a rapid movement in the day.
Moments in the
Your experience, what do you think?
yeah, okay. I'll put it, I'll put a disclaimer over here. It's going to be just a, like assumptions or a thought or how it's going to be. So the one thing that you can do it, look into it is like, definitely, if you look into the past for this year itself, there is not any moment with the consulate. The first one is about the consulates are closed for the time period with the quarantine and everything. And the second one is COVID-19 that was happening. And the second part is about the executive order where it limited, the approval of the green card in the consulates. And all these numbers had definitely added up or helped then the Department of State to have the visa numbers available. And so definitely there is a lot more available. That's what the assumption or the thought process is. And then that too started with the fiscal year of October. Always, if you see that, as we said, compared to that of the H1B, it starts with October 1st. All the numbers are available, and depending on the use of it. But definitely, there is still the 7%, limitations on the country quota that's still going on. So there's no change onto that, and suddenly how it opened up is not. So all these numbers are available. So they are trying to make use of those numbers, and that too when it started with the fiscal year. So there is definitely a possibility of moving forward, but again, going back, as I said, in 2007, it was very open, anybody who had an approved I-140, there was no limitation of, the cutoff dates or anything. It was an open call that was given in 2007. And then, in a month, the next one went back, completely gone. So it's all the decision of the Department State, USCIS on all the other related, like this one, but there is, in this one, they're saying there is a possibility to move forward. But I would say again, don't rely on that. So the one thought process I would consider you to take into consideration is keep everything, start everything, work on all your documents, papers, and then, October 31st is the last day to be received on this current visa bulletin. So you can have everything ready even on October. You can decide, see to it. If you're in a dilemma, how do I proceed further? Whether, I'm going to wait for it or how it is. And that is one thing that you can consider. But, it's definitely said it's going to move forward. Don't ask me for the how long anything. I don't want to put anything towards it.
I would put a disclaimer for both you and me. These are all views.
Yeah, right.
Guys, if you think that you have and you can relate your stand with all the views, but always advisable to reach out to an immigration attorney. Mary can help at any point of time if you need help. So it is always advisable to reach out to an immigration attorney specifically with your state, and do not assume, do not presume. Yeah, so these are all the discussions and the views. So I would request, if you think that there is anything that is in specific that is required for your case, it is always advisable immigration advice. specifically for your case.
Right, yeah, that's totally true. And it makes a lot of difference in your decision-making process, rather than, just listening to, so now Google is the best of a lawyer or a, doctor, right? So better is to talk and then, find it out. And just to add it up before I, move forward, so because these are all very, like important decision-making thought process for anyone. If you have your spouse as well having an approved, like an I140, the best is to do is to, I always tell them, even as a regular process, whatever we do, even though they qualify, always it's all about the EB2 till this time, because it was understandable at earlier point, one point of time, it was so much moving forward. So it's not wrong, but if you have an option or a choice that your wife is also employed and she's also to be filed for, keep it, as the other option, like doesn't matter, it has to be both or EB2 or EB3. So just keep the other one. If the spouse is there, even now as an alternative, if one of you qualify and then you're able to downgrade it and the other one's is I-140 is untouched, it's still intact as one firm and one approved, and you can always go back to that, then in that case, you just keep your option open and try to see there is a possibility that comes under you so that you can take the risk of moving forward and downgrade it. And you don't have to, as one point is like, 1485 has been filed for a family at any point of time in the further, say that final action date has come up on that, the other spouse. It's little more technical. I don't know how far you can understand, but it's called cross filing.
Yeah, yeah. That was one other question maybe which we had in our file, but before you started talking about, yeah, there were a lot of questions related to this. For example, let's say that one of them between the family, one of them is having an application in EB3 and with an approved I-140, and the other spouse is in EB2, and the priority dates are yet to come. So here was if they can file I-485 for the spouse who is in
eligible to file for
in
the
the yeah, and if we file I-485 with the spouses, the other person's
right.
category, will there be any issue with the other employer? I mean, if they are not with the same employer, I mean, most probably that's the case. So will there be any problem to the EB2 dates which they have not used or for filing 485?
No, I don't see that, as long as anyone, say, for example, husband is on with an employer EB2 and wife is on an EB3 employer, and then the wife's eligibility date is there for the visa, and so she's filing for it. So husband becomes one of the applicant, for the 485. And even though he has another approved one and he's working for a different employer, no, the wife will become the primary applicant and he will be the, the spouse applicant for the same 485. And it doesn't create any issues or later point of time, like anything unrelated. I don't see that. Definitely the documentations are all there, which we have to look into it. But I don't see any kind of an issue just because, he has an EB2 I-140 approved or any kind of an unrelated. No, that is not.
Okay.
So that's the one time you file for it. Say that, just quickly to connect it. So say that, like if for luckily the husband's priority date is even moving ahead after they file the 485, then comes the interfiling, cross-filing, where, we, through an attorney, they connect the files and the priority dates and they move forward. It's a little more technical, but it is also doable. There are very many options, but only thing is you have to get a proper guidance and a counsel towards it.
Yeah, so this was one other thing probably people would definitely be because they were originally thinking that, okay, if will I be able to apply 485 with my spouse because I have another employer, I'm with another employer and he holds my, he or she holds, that company holds my green card. So I think this is also a welcoming thing where a lot of people can utilize this particular opportunity and file for 485 slash EAD or adjustment of status. Okay. Thank you, Mary. Thanks for the for answering. So one other interesting question here, Mary. So once again, I think you can express your views. There is always an answer behind it. So as the EB3 dates have come closer, let's say that there are a lot of downgrades that are happening. So do you think if bulk conversion of EB2 to EB3 downgrade from an employer is considered as a fraudulent activity or something?
Actually, it is going to be a very general question because it involves so many, factors to be considered. So when it's going to be, number of employees, the purpose, the process, and everything. So I wouldn't be very specific to my answer. There are multiple filings always raises an RFE on the I140 and then to prove the ability to pay. So they have to list out all the filing that has happened from an employer perspective, and they have to justify it, the ability to pay, and so many other criteria. I would definitely leave it to the employer and a call to the attorney and decide that it is open because it becomes a little more very specific, actually, an answer for this.
Thank you, Mary. Thank you very much. So the next question is, I think these are the generic questions, repeated questions that we had from community. So let's now go to the YouTube link.
Okay.
The questions, there are a lot of questions there. Probably we may not be able to
address all of them. Okay.
All of them, if considering the time.
One quick thing,
Sure.
so when I'm talking to you, just moving back on my phone, close by, they're asking, can we have another session with my?
Oh, yeah, sure.
No, I'm just saying, I will try my best when you send the link as well. We're totally busy with all those things, but as I said, it's not about for me. I work with a passion, and I want to step in. You would have known by now. Anywhere I can help it out. So I will try to address whatever, if it's something very specific to their case, I will definitely do that at a later point of time. But anything you can, if you have any questions, we can go ahead and I will try to just talk about it.
Thank you, Mary. One other question is what are the possibilities or probabilities that you think of getting RFEs during this downgrade process?
See, as I said,
I know it's it's a vague question, but still we are trying to understand because these are all possible things with USCIS.
Yeah. So it depends on, definitely on so many criteria. As I said, I'm more concerned about is the ability to pay for the smaller employer who are, lesser than 100 employees on the payroll. That's such a very general question that is going to come up, matching up, and they would have filed the green card, for multiple people who might have been continuing to work, or sometime it might be a future employment. So all those listings are to be considered before the employer steps in to decide, and you also have to be, involved in the process. So that is the one major concern I have. If they would have been able to maintain the record of the financials of the company, because as I said, the qualification on the individual is one of the other requirements of an I-140, which I assume definitely it would have been approved on a higher level of it. So definitely, the detailed experience letter or the education qualification, that and all would have been earlier supported. So my more concern is about the ability to pay, where it might be something to result in an RFE. And as we talked about, so multiple filing at the same time because they don't have long time to work on it, just the window of October 1st to 31st. So the employer is also forced to, file for the petition of the I-140.
Okay.
Right. That is one of the possibilities.
Okay, thank you, Mary. Another interesting question is, do we need an employer to file I-485, or if we have an approved I-140, will we be able to reach out to any of the immigration attorneys to get help with?
No, one of the criteria is like, you should have a future uh,
Employment.
employment offer that is available when you file the 485. So earlier we used to do it with just an offer letter acknowledging or, like moving forward from the employer, not acknowledging. It's 100% of the employer accepting that this position and is to be, like I am willing to offer the same position that was filed for, and then we attach it. Now comes the 485J, which fulfills that part of it where you have to provide the employer signs on that form in particular when we move forward, because it's acknowledging that the employer is also in part of the process. So that is one of the major questions we had at the earlier, when they opened the visa. I'm not even with the old employer because of other criteria. I took a full-time position with my direct client where they didn't file for my PERM, but my employer, I'm not in contact with my employer. Can I use that offer and file for this? No, that will not be possible. So you have to go back to the employer and ask them, and you don't come under the financial ability and the criteria when you do this onto the 485 only option, only like the employer is agreeing or abiding is by the 485J on part of it. And there is so many other criteria that comes under later point of time, 180 days of filing and all those things. That is a little more detail. But again, at this point of time, you cannot go with the employer who is not willing to sign the 485G.
Okay, so thank you, Mary. So the next question is another interesting question. So he's saying that I'm on EB2, planning to submit an concurrent I140 and 485 in EB3. If my EB2 dates become current, can I switch to my can I switch my I140 485 to use EB2 while the EB3 I140 is still in progress, or it is still not approved, or something like that?
Actually, it is.
Yeah, I'm also confused with the question, because once you once you concurrently file
Right.
485 and the dates are still, like, are more closer than the EB2. I somehow I think that this question is, like, how the person who
Yeah,
assumed
and
this,
yeah.
because of the downgrade, the EB3 might go a little back, and EB2 might come forward. So do you understand the question, right, Mary?
Yeah, I got it. So then I would say one thing is, okay, they are moving ahead with that filing, and it's going to be in a regular processing to the most part of it, the I-140, and they're filing the 485. So the one thing they, like say that, like they are going to be doing it is like always they can withdraw that as long as it's not, like the decision is not made in. But the problem involved is like, they are going to spend a lot more again. Say that, I understood the question on the context of what they said. So again, like say the withdrawal is not going to affect them. So the decision is not made. So the only thing they'll be losing is the financial part of it, because they would have been ending
Yeah.
up a lot more spending onto it. Say that November, they see that my EB2 is current. Why do I go for the downgrade? They can always look forward, but whatever has been applied for the 485 is attached to that of the I-140. So you can't do an interfiling or a cross filing. So then again, they will be withdrawing both of them, and they have to refile everything depending on the process of the EB2. So that is all a call that they have to specifically address it and take it over.
Okay. So another interesting question is, um, I have an I-140 with August 2000 date, priority date in EB2. And there is, with the current employer, the I-140 is still in progress. Can I file concurrently for this downgrading, or do I have to wait for my current I-140 to be approved? Or is it possible they can withdraw the pending application?
Oh, can you repeat it? I'm very sorry. I'm
No,
trying
no, no,
to.
no, no, no problem. So he's saying like they have an I-140 approved with August 2010
Okay,
and
EB2. Okay,
EB2,
okay.
and they have another I-140 which is approved. Which is in progress.
Uh-huh.
The question here is, I think that, I assume that this current I-140 may be with a new employer.
Uh-huh. Yeah, right.
Is, can I file concurrently a new application, or do I need to wait for my current I-140 to be approved?
Actually, no. So the kind of I'm assuming this question
So
on.
yeah,
So
this is little vague question,
yeah,
but I
no,
think
should be
this is what I assume. Yeah, go ahead.
yeah. So I'm kind of, see, the one thing is they are they are putting the priority date from that of the April 2010 to that of currently filed I-140. Okay, so they have a receipt notice. It might be in the regular processing, probably, or even a premium. So unless the I-140 is approved, the priority date is not ported actually. So what they can do is they can upgrade it to a premium processing, because they have a window of 31 days. So upgrade it to the premium processing. If it is not done, get the portability of the old I-140 of 2010, and then, file an 485 immediately. But when it's in the process, they cannot do it unless the old employer, the April 2010 employer, is ready to do that. With the new employer, they have to have an approved I-140. That's when the portability of the dates comes in.
Okay, sounds very interesting.
But
Another,
very, Ashok, and very interesting questions. I really,
yeah,
I feel every question, is very in depth, and very glad. Sometimes, it's all routine things, but all these
yeah.
questions are really
As we talked earlier, it's all sentiments.
attached to it, and
It
definitely,
is,
like,
yeah, it is.
I feel it adds value to each one of them listening. Even I would say, just give me the link for the video, and I will try to, from our office, there is one other senior person, and, like, maybe I might not be able to find the time. I'll try to put it in as an, the answers and everything. But I really find it very interesting. Actually, all these questions are.
Thank you, Mary. Yeah. So, next question, the one other the most asked question is, what are the documents that you need for progressing? Now, if let's say that someone is eligible, what is the process, or what are the documents that they need? I know there is like a medical involved. We have to apply for 485, 765, and adjustment of state.
Transfer role and so
If you could
many.
explain, that would be great. Yeah.
Yeah, sure. I thought I'll put it at the end, but we can go forward. That's fine. Actually, so you have to be very careful with the 485, because there is, it looks like a simple document, but there are so many things to be put together. And particularly the 944, like the public benefits, the form that has been added, and when you're adding up, there are very particular criteria that has to be looked into. The form itself is very confusing, even for our clients who started the 485 process. We started immediately using our portal. So, we are very specific to address that particular, question of what are the documents and everything. Say, for example, if your spouse doesn't have a social security number, but there is a criteria which says the credit report is something needed. So we have to address it in a very different way. You have to run a credit score and say, for a no SSN number, still run a credit score, put the screenshot, and then add it up. So, there are a lot more of documentation that is related to the 485 filing. So I would ask them to be very careful about it, and then add all the documents and the signing, and the new fees is coming into effect in October, 2nd. So all these are to be put together properly in the signature where it has to be needed, because one signature will, deny the whole documents. On top of it, you don't have the time to refile it, because by the time if it moves back, unfortunately, so you have to be very careful. And so the one part of it about the medical list, I definitely say that it's the call of the law firm or whoever it's filing for. And, like 693, as per the checklist of the USCIS, is non-mandatory, but at the same time, in the last few months, we happened to file all the documents, for few of them who got lucky with the priority date. And also we do other family-based filing as well. The parents filing for, and like the children from filing for the parents and other things. So the 693 is not mandatory, but what we saw is like, they have every reason to return back your packet. So take the call, talk to your attorney, and we are including the medical, even though we know the validity is only for a year and we never know how it's going to be, but still not to take a chance with, for people who had waited all this time. So we are just advising them, and we have started the process of all the whatever has to be done and everything. And so they have to be very careful when putting together all the documents, and the alternates are there for the birth certificates. Try to get it, and the copy is fine. The signatures till now, USCIS is accepting the scanned form signatures, but it has to be original signature as mentioned, not a DocuSign or something. So all these are very specific to the packets that they are going to be filing for. So cautiously, I'll ask them to, just do it very, or else, it's going to be, the consequences are very hard.
Yeah, absolutely. Yes. And we know all this. We have been done. We have been going through this
Yeah,
RFE thing for a long.
on the timeline, I would appreciate as though when always, any questions on your, like whatever you do, but I know it's nothing to do with once you get your green card citizen done, but you are always involved. And the first time the visa bulletin got, and the first text was from you actually.
Thank
I
you,
was
Mary.
just going through it morning, and then you said, Mary, what is happening with this one? So, I appreciate your interest towards the society, because it's not all about us, right? You're just there to help others who are going through the same process of it. Thank you.
Thank you, Mary, and thank you always for answering all our questions. Yeah. So on the time perspective, I think we have just 3 more minutes.
Okay.
One, let's go through a few other questions. So there was one question: what is the validity of EAD? I know it's like 1 year, right, Mary? If I'm not wrong.
For this coming up
No,
for
for
the
EAD. For EAD,
it will be for 3 years
3 years.
actually.
EAD is for 3 years. Okay.
And then, yeah,
Okay.
so
Okay.
they can keep 180 days prior to that they can file for it. But
Okay.
again, the fees is going to be separately paid for when they are going to file it after the October 2nd. That is one of the catch. That's safe.
Okay. Okay. So one other question is: let's say that someone got an EAD. The question is, does that person have to maintain an active job always?
So the EAD, no, so the 485 EAD, I'm assuming it's not going to come at least for more months. The reason is with a large number of filings. And even if it's a primary applicant who had filed for the 485 and then he gets an EAD and he's trying to switch jobs, that is a very different, consideration. They have to do it with 180 days of portability and how far with a new employer filing the 485. That's a very detailed one. Maybe we have to do it after some more point of time. But EAD is open options. They can work with anyone, and like it doesn't have to be specific to any employer.
Yeah.
So they
Yeah.
can get it pretty
I
much.
can understand where this question came from, because when you are in H1, you always have to maintain an active employee.
So, yeah.
So
But at the
once,
same time, I would just as a to put added together, as long as you have an option to maintain your H1 status, non-immigrant status, always try to maintain it irrespective of 485 being filed for, because anything there involves a lot more in a 485. It's all about the individual, their record of stay, their entry, their W2, so many fingerprinting, so many things are involved in the 485 stage of it. So just don't rely on the 485 alone. Just, like always keep your non-immigrant status on the H1, H4, L1, whatever it is.
yeah, that's, I mean, even anyone who I discuss with, I definitely personally advise, it's not a legal advice, advise that though you have an EAD or though you have an current, I mean, have an continuous employment, you think you may have, if you switch to an employer, new one, it is always advisable
To maintain.
please be on an H1 or L1, because you can always renew that. But
Renew that based on your I140, worst case, I'm a very optimistic person. I'm very hope, anyone talk to me, I give all the hope available. But at the same time, you have to be, what you have to do, you have to do. That I always tell them, when you have an option, try to, just maintain it as much as possible on that part of it.
Okay. Yeah, looking at time, Mary, it's 11 o'clock and we agreed for an hour. Thank you very much for your time. Before we conclude, Mary, there are a lot of questions that are still coming in. There are more personal questions, meaning what we did is we tried to generalize all the questions from the questionnaires that we had. I mean, from the from the group of questions that we had. There are more questions that are related to their particular scenario. What do you suggest? I mean, do you think if you will be, I mean, like there are two things that we could do is, I mean, as you said, there are many requests that to have one more session, possibly with an extended time so that they can have their questions pulled in. Number one, I would I would request a time for that, which I know you will definitely say no, definitely yes. I will presume. The second thing is very, I mean, for all these personal questions, what do you think? I mean, how do you think they could reach you? I mean, do you think if they can reach you during the week, or how do you think to reach? I mean,
so then I definitely, like, see, but whatever the best I could do, I'll try to do it. What I would say is ask them to put a reference and then send an email to us. That will be the best way for me to get in touch with them. I can provide the email ID, legal at mkimmigrationlaw.com, legal at mkimmigrationlaw.com, and we have a Facebook page as well. So if at all, like you want to just send anything in particular, definitely, you can send us an email on that.
yeah.
And then
what we have done right now is Mary Proud. I mean, you might have seen, you can see.
Yeah, I'm seeing the screen on that.
Yeah.
Right.
So we put the slide together so that we thought
Sure.
everyone. So please send us send questions for a consultation to legal at mkimmigrationlaw.com, and there is a number that has been displayed in the screen. So please feel free to reach out to Mary. And Mary, to the next to the earlier question, you haven't answered it, but still, do you think if we will be able to have or hold another session coming days?
In coming weeks, actually, so then let's see how it's going to be helping them out with the response. Like I'm open for it. We can just try to put it together and see, like what kind of a questions, how much, they want to know about it. Yeah, definitely, I'll do that.
Okay. Thank you, Mary. Thank you very, very much for all the questions. I know there are a lot of questions,
Sure.
but still, we are very sorry considering the time duration. We try to cover most of the generic questions that or specific questions that came from a lot of people. But still, we are very sorry if we did not find time to go through your questions. As we just said, now how to reach out to Mary. Please try to reach out to her. She's always a good person to reach with, definitely. And try to put in your questions, try to get help with, and let's see if we can get a chance to have another session in the future. Thank you very, very, very much, Mary, for your time, your support, and your extended support to the community here in the Midwest area. We wish you all the best, and thanks for your time, and wishing good luck and success to all the people who are going to apply for the 485 or EAD as of October 1st. Yeah, go ahead, Mary.
Thank you. So thank you so much, Nandri.
Thank you. Thank you all. Thank you. Bye.
Bye.
So thank you. Thank you all. Thank you very much. Thanks for your time. At this time, we would like to thank all our team from the GMTS and also from the partner organizations, mainly Chicago. Thanks to Prasad for your quick response. I mean, you won't believe we tried to reach out to me on the Friday and Thursday, and we got everything collaborated on Friday, and we were able to get in today. So thank you, Prasad. Thank you, Kingsley from Michigan Tamil. Thank you, Karthik from WITS. Thank you, Sundar from Minnesota Tamil. And thank you, Suresh from TagDB. Sorry, we were unable to get you in the flyer earlier. Thank you all. As we said, we will try to have another session with Mary based upon the time and also the need. Please, if you think that you are unable to help, if you are unable to reach out to Mary directly, please feel free to reach out to one of our board members in GMTS as well as to your organizations. And we will be able to direct all those questions to Mary at any point of time. Thank you all. And at this time, I would definitely wanted to thank our proud sponsors of 2020 of GMTS. Without you guys, we will never be able to be so much successful in running this organization. Thank you all, and have a good day or have a good rest of the week. Thank you all. Thank you.